at this moment in history. He will ensure that the department meets the critical challenges facing America. Throughout his career at the Justice Department and as judge on the D.C. Circuit, Judge Garland has demonstrated that he has the experience, judgment, independence, and dedication to public service necessary to excel as Attorney General. I'm sure today's testimony will further illustrate the judge's qualifications. Today, we welcome five witnesses who are supporting Judge Garland's nomination to be the 86th Attorney General. Each will offer a different perspective on Judge Garland and the experience and talent he would bring to that role. I'll introduce the majority witnesses, then I'll turn to Ranking Member Grassley to introduce the minority witnesses. Our first witness in the majority is Wade Henderson. He is the CEO of the Leadership Conference on Civil and Human Rights, served in that position from 1996 to 2017, currently back serving as their interim president. The conference consists of more than 220 national organizations working to ensure equality under the law. Mr. Henderson can speak to many issues facing the Justice Department, such as the right to vote and reform of the criminal justice system. Andrea Tucker is a special witness, and I thank her for joining us today. She's a native of Washington, D.C., and a mother of 3 children who are in the D.C. public school system. Judge Garland tutors her twins, who are now in the 6th grade. Ms. Tucker can speak to and give us a valuable insight into the judge's character and his dedication to the community. Donna Posella has held many public service roles across the federal government, from the U.S. Army Judge Advocate General Corps to several positions in the Department of Justice. She worked closely with Judge Garland when he led the investigation of the Oklahoma City bombing, and she is going to share that experience with us. Ranking Member Grassley, would you like to introduce your other 2 witnesses?
Yes, I would. Ken Starr is an attorney, academic, and public servant, and also appears on a lot of television as for interviews and explanations on legal matters. He earned his undergraduate degree from George Washington University, master's degree from Brown University, and law degree from Duke. After law school, Judge Starr clerked on 5th Circuit for Judge David Dyer, and then with Chief Justice Warren Burger, Supreme Court. Judge Starr spent some years in private practice before serving as counselor to Attorney General William French Smith during the first term of the Reagan administration. In 1983, Judge Starr was appointed by Reagan to serve as a judge on the U.S. Court of Appeals for D.C. Circuit. Judge Starr left the bench to serve as Solicitor General under President George H.W. Bush, and then served as independent counsel investigating President Clinton during Whitewater. After his service as independent counsel, Judge Starr returned to private practice as an appellate lawyer and law professor. Judge Starr also served as dean of Pepperdine School of Law and president and chancellor, Baylor University. He has argued 36 cases before the Supreme Court, authored more than 24 publications, and received numerous awards for his public service. We welcome Judge Starr. The next person is Josh Blackman, professor and professor of law, South Texas College of Law in Houston. Professor Blackman received his undergraduate degree in Penn State University before receiving his JD, George Mason University School of Law. Both degrees were magna cum laude. Professor Blackman clerked for Judge Kim Gibson, Western District, Pennsylvania, and then Judge Danny Boggs of the 6th Circuit. During his career in academia, Professor Blackman has proven to be a prolific author and an expert in constitutional law, healthcare, the Supreme Court, and many other subjects. He has also testified 3 times before the House Judiciary Committee. I believe that this is the first time testifying before the Senate. We welcome both Judge Starr and Professor Blackman.
Thank you, Senator Grassley. Because our witnesses are appearing via video, I'll lay out the procedure we'll follow. The mechanics are the witnesses will be sworn in, then they each have 5 minutes to provide an opening statement, and then they will be open for questions. The first round of questions, each senator will have 5 minutes to ask. So I'd like to start by asking the members who are witnesses today to raise their right hand and to please, do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Let the record reflect that the chair heard "I do," which is an indication of good results from the oath being given. We're going to start with Mr. Henderson to proceed with your 5-minute opening statement. Please proceed.
Good morning. Good morning. Chairman Durbin, Ranking Member Grassley, and members of the committee. I'm Wade Henderson, Interim President and CEO of the Leadership Conference on Civil and Human Rights, a national coalition of over 220 civil rights, human rights, and social justice organizations dedicated to building an America as good as its ideals. Thank you for inviting me to join today's hearing to support Judge Merrick Garland's nomination as Attorney General of the United States. Now, when President Biden nominated Judge Garland, he rightly instructed him, and I quote, "You are not the president's or the vice president's lawyer. Your loyalty is not to me. It is to the law, to the Constitution, to the people of this nation," unquote. Indeed, the Attorney General must be seen by every member of the public from every community as a fair arbiter of our legal system whose sole duty is to serve the national interest. Unfortunately, our two most recent attorneys general failed to live up to this high standard. From their unconscionable validation of President Trump's subversions of voting rights and our democracy, to their inhumane separation of families at the border, to their abuses of our justice system, attorneys general Sessions and Barr all too often served as loyalists rather than independent law enforcement officials, and in the process deeply tarnished the reputation of the Department of Justice. Nowhere has the damage been more apparent than in efforts to undermine civil and human rights, and my written statement lists many of the harmful anti-civil rights actions taken by President Trump's Justice Department. America is in dire need of a course correction at DOJ. The nation needs an Attorney General with a demonstrated commitment to integrity, independence, and the enforcement of civil rights. And DOJ must embrace our nation's tremendous diversity while protecting the rights of individuals and communities that have borne the burdens of systemic discrimination in all its forms. Judge Garland, who is widely regarded as one of the top legal minds in the nation, embodies these principles. I first became familiar with him as a nominee to the U.S. Supreme Court in 2016. As then president of the Leadership Conference, I had the responsibility of reviewing Judge Garland's record, and I became deeply familiar with his views. I presented those findings in various public forums, including on C-SPAN's Washington Journal. I believe now what I believed then. Judge Garland is a jurist with a first-rate legal mind and great personal integrity, and he has consistently written and joined opinions that have upheld civil and human rights. Several of our member groups and allies reached similar conclusions. Frankly, he should right now be on the U.S. Supreme Court. That said, however, President Biden's selection of him for this position is an inspired choice. He, along with the Leadership Conference's own Vanita Gupta, our board member Kristen Clark, and attorney Lisa Monaco, are the right team for this trying moment. If the issue is restoring the integrity and independence of DOJ, and it is, then Judge Garland is particularly well chosen. If the issue is restoring the mission of the institution, including its commitment to addressing civil rights enforcement and attacking racial inequality, and it is, then Judge Garland's own words speak best when he recounted so movingly yesterday how the DOJ first forged its identity fighting against the Ku Klux Klan and working to bring meaning to the 13th, 14th, and 15th Amendments of the Constitution. For these reasons, we support Merrick Garland to be the nation's next Attorney General fully and without reservation. I should be clear, however, that this support does not come without expectations for prompt and meaningful action on civil and human rights. My written statement outlines several priorities that DOJ should quickly address, among them suspending the use of the federal death penalty, rooting out addressing white supremacy and hate violence, and helping to secure the right to vote for all Americans. The need for robust federal civil rights enforcement is as important as it has ever been. The nation needs a Justice Department that will do everything in its power to provide equal justice to all. We need an Attorney General who knows the Justice Department well and who will reinstate DOJ's historic commitment to integrity, independence, and vigorous civil rights enforcement. Merrick Garland would be such an Attorney General, and it is therefore a fitting choice to lead the Justice Department at this crucial moment. We urge the Senate to confirm him, and thank you, and I would be happy to answer any questions. Thank you.
Thank you, Mr. Henderson. Professor Blackman?
Thank you. Chairman Durbin, Ranking Member Grassley, thank you for inviting me to testify. My name is Josh Blackman, and I'm a constitutional law professor at the South Texas College of Law, Houston. I support the confirmation of Judge Garland. He should be swiftly confirmed. In my brief time today, I will discuss 3 current DOJ policies that I hope Attorney General Garland will maintain. First, DOJ lawyers should not give legal effect to so-called rulemaking by guidance. Second, Attorney General Garland should carefully scrutinize consent decrees, especially those reached through so-called sue and settle. Third, DOJ should not resume the settlement practice of giving third-party payments to non-parties, that money should be returned to the Treasury. These 3 issues may seem fairly low profile, but each practice will have a huge impact on the separation of powers, and these issues should be important to people on both sides of the aisle. I hope that Attorney General Garland will retain current DOJ policy with respect to these 3 issues. First, the Department of Justice should not enforce rulemaking by guidance. In the past, federal agencies avoided the formal rulemaking process and instead issued various guidance documents. For example, substantive changes to the law were made through Dear Colleague letters, frequently asked questions, and even online bulletins, what I called government by blog post. These guidance documents are not supposed to have the force of law. However, courts grant our deference to the sub-regulatory dark matter. In 2018, Associate Attorney General Rachel Brand instructed DOJ lawyers to not treat violations of guidance documents as violations of the law. And President Trump signed Executive Orders 13891 and 13892, which ordered other agencies to adopt the principles from the Brand memo. Unfortunately, President Biden rescinded those executive orders on his first day in office. At present, the Brand memo is still codified in DOJ regulations. I hope that Attorney General Garland will maintain the Brand memo. Second, Attorney General Garland should carefully scrutinize consent decrees. These agreements include intricate requirements that DOJ could never impose through regulation or litigation. And these consent decrees can exist in perpetuity. During this time, federal judges and court monitors can oversee state and local governments. Such agreements raise distinct federalism concerns. Indeed, many of these agreements arise from a practice known as sue and settle. Organizations and local governments would sue a like-minded agency, knowing there was no adversity, and reach favorable settlements. Fortunately, Attorney General Sessions took actions to restrict those consent decrees. The Justice Department imposed restrictions on consent decrees, including limits on duration, sunset provisions, and means for termination. Critically, under Attorney General Sessions' guidelines, a consent decree could not be used to achieve a policy goal that could not be obtained through litigation. I hope Attorney General Garland will maintain this policy. Third, the Department of Justice should return any excess settlement funds to the United States Treasury, rather than make third-party payments to progressive groups. These payments have been criticized as settlement slush funds. The federal government has allowed billions, not millions, billions of dollars to be given to third-party nonprofit organizations. These special interest groups were not parties in the litigation and were not victims of misconduct. Indeed, Senator Grassley has observed that the Justice Department directed funds at organizations that Congress had defunded. In this way, the executive branch bypassed the Constitution's appropriations process. In 2017, Attorney General Sessions prohibited the inclusion of third-party payments in settlements. Any excess funds from settlements would be restored to the United States Treasury. Attorney General Garland should maintain this policy. Thank you for your time, and I'll be happy to answer any questions.
Thanks, Professor. Ms. Tucker, the floor is yours.
Good morning. First, I would like to say good morning to Chair Durbin, Ranking Member Grassley, all of the members of the Judiciary Committee, and my fellow witnesses. Thank you so much for having me here today. My name is Andrea Tucker. I am a native Washingtonian and the proud mother of 3 scholars in DC public schools. I am honored to be here today, and I'm thankful for the opportunity to come and speak on behalf of Judge Garland. I met Judge Garland roughly 5 years ago when he came to my children's school to meet with one of the 5th graders he was tutoring at the time. Unbeknownst to me, a few months later, my then 2nd grader would have the honor of becoming Judge Garland's next pupil. This was something that my child's teacher thought he could benefit from, specifically to help bring him out of his shell and to help with his reading comprehension. Judge Garland normally tutors a student until they graduate elementary school in the 5th grade, and then he starts with another child in 2nd grade. So over the last 4 years, Judge Garland has had weekly tutoring sessions with my son. At the end of every school year, Judge Garland has always invite all of the children of the tutoring program, which he started, to the DC Circuit Court of Appeals for a tour, to see the courtroom, meet the U.S. Marshals and the Marshals' dogs, and get a feel for what it was that Judge Garland does for a living. Judge Garland also has a pizza party for them, where they exchange gifts and other educational materials so students can continue their learning over the summer. One year, when my son was struggling with multiplication, Judge Garland gave him some flashcards to practice with over the summer, so Judge Garland could quiz him when they returned the following school year. Of course, the past year was a bit different due to the pandemic. Judge Garland didn't miss a beat. He quickly pivoted from tutoring in person at the school, once in-person tutoring was no longer an option, and contacted the school's tutoring coordinator to get my contact information, and he offered to virtually tutor my son. On top of that, he knew that my son had a twin sister in the same class, so he also offered to tutor my daughter. The judge felt like all students could benefit from tutoring and extra support, not just the ones that are struggling and behind. What parent would turn that down, especially during a time like this? So in the end, Judge Garland coordinated with my kids' school to get all the appropriate work packets and tutor both of my children once a week on Zoom, carefully guiding them through virtual learning and their schoolwork. All the extra help was much appreciated. The fact that he still wanted to tutor during a pandemic and give so much of his time to both my children was amazing. This shows his dedication to our actual community and love for children. One thing that made Judge Garland such a special tutor was he always began each session with asking how my children were doing and what fun and interesting things they did since they last met, getting to know them and engaging them on a personal level. He made tutoring fun, interactive, and effective. Or in the words of my daughter, I quote, he made tutoring and math more fun and understandable for me, unquote. I mentioned earlier that when a student graduates 5th grade, Judge Garland usually begins with another student. But as my children approach their 5th grade graduation, they asked Judge Garland if he didn't mind staying with them for the upcoming school year if they were online. He quickly agreed. My children are now in 6th grade, and I could see their work with Judge Garland paying off in their grades. When you confirm Judge Garland, and I believe you should confirm him quickly, he is eagerly looking forward to getting back to his students to continue tutoring them, even as he settles into a new challenging role. This speaks to the character of the man who will serve as Attorney General. He is a man who actually does what he says he will, not one who just pays lip service to helping our communities. Character, commitment, and dedication, someone who will do what they say they would do, that is what you're getting in Judge Garland. Thank you.
Thanks, Ms. Tucker. Appreciate that. Judge Starr?
Well, thank you, Mr. Chairman, and Ranking Member Grassley and members of the committee. I'm so honored to testify before the committee today. Since 1789 and General Washington's nomination of Virginia Governor Edmund Randolph to serve as our nation's very first Attorney General, few nominees to the office have come before the committee, before the Senate, with Judge Garland's extraordinary array of credentials. We just heard one, by the way, from Ms. Tucker, and that's his generosity of spirit. I'd like to focus very briefly on leadership and the universal respect that the judge garnered during his years as Chief Judge of the D.C. Circuit. He was not only viewed, as he is, as a superb jurist, but he was a superb leader of the court, a leader who listened carefully to his colleagues and who treated all persons in the court family with dignity and respect. But history teaches us that the role he will soon be occupying, if confirmed, is extraordinarily difficult. My late boss, Attorney General William French Smith, during the Reagan administration, compared the job to that of the captain of a hypothetical javelin team that elected to receive. It's a hard job, and controversy, at times quite bitter, goes with that territory. Consider the example of Attorney General Janet Reno during the Clinton administration. She was vehemently criticized, I think unfairly, for her decisions to appoint several independent counsels during President Clinton's first term. And yet, as she made crystal clear, the law that was then in effect required nothing less. And her determination to do the right thing was mirrored by the outstanding FBI director at the time, Judge Louis Freeh. This bedrock requirement of doing the right thing, of integrity, has been spoken about frequently during the course of these hearings. And frequently, the reference is made to the independence of the Justice Department. But as Judge Garland full well understands, in our constitutional architecture, executive power is vested in the President of the United States. So how can, as a theoretical matter, any Attorney General be truly independent while serving at the pleasure of the President? Indeed, there were attempts made in the immediate wake of Watergate to reconstitute the department as an independent agency, a very bad idea and constitutionally suspicious. The answer to this conundrum is independence with accountability, lying in the very qualities that Judge Garland has shown through his long and distinguished tenure, and that is independence of judgment. And that is, the Attorney General must be allowed to make the pivotally important decisions unimpeded, especially with respect to the most sensitive work of the department, that of the criminal laws. And at times, the resulting decision may draw the ire of White House personnel, perhaps even of the President himself, as history teaches. But his commitment to integrity and professionalism is a total way of looking at the job, I think, was reflected in the work of Judge Griffin Bell and his contribution during his tenure as Attorney General. And Judge Bell's vast judicial experience, like that now of Judge Garland, made itself manifest in the way in which he conducted the office so honorably, and his aptly entitled memoir, Taking Care of the Law. That's the job. Very briefly, the second broad area likely to be rife with controversy in the coming months is that of protecting religious freedom. Over the past decade, a number of voices have been raised, drawing into question long-settled principles of America's very first freedom, guaranteed by the majestic opening words of the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Here again, I think Judge Garland's distinguished judicial service points to optimism about the Justice Department's protecting religious liberty. His body of jurisprudence reflects stability and predictability as huge values in the law. And thus those of us who have long supported the Religious Freedom Restoration Act are optimistic. After all, the Religious Freedom Restoration Act, called RFRA, is the leading federal civil rights law that protects all Americans in the exercise of religious liberty. It also embodies the constitutional perspective and jurisprudence of Justice William Brennan, for whom Judge Garland served as a law clerk. This is, in short, settled law. And it's crucially important that the Department of Justice not support any legislative or executive action that would dilute the vital protections that RFRA provides to Americans of all faiths. I thank the chairman, and I look forward to your questions.
Thank you very much, Judge Starr. Ms. Posella?
Chairman Durbin, Ranking Member Grassley, distinguished members of the committee, thank you for allowing me this opportunity to testify at today's hearing. I've had the privilege of knowing Judge Garland since 1993. We worked together at Justice from 1993 to 1997. At that time, I was the Principal Deputy Director of the Executive Office for the United States Attorneys, the organization that oversaw the 94 U.S. Attorneys' offices. Judge Garland and I had constant contact over those years, and I witnessed Judge Garland make sound and factually based decisions every day. I've been honored to serve our country in various roles, some of which include Assistant United States Attorney for the Southern District of Florida, the Director and the Principal Deputy Director for the Executive Office for United States Attorneys, the United States Attorney for the Middle District of Florida, the Director of the Terrorist Screening Center. One of my most life-changing experiences happened while working with Judge Garland in Oklahoma City after one of the most horrific domestic terrorist acts was committed on U.S. soil. On April 19th, 1995, 168 people were senselessly murdered in Oklahoma City. That day, Attorney General Reno asked me to go to Oklahoma City. I went to offer assistance to the U.S. Attorney's Office and found that the entire downtown was a crime scene. Within 24 hours, Merrick arrived and immediately began leading the investigation. I had the opportunity to see Merrick deal calmly and purposefully with this horrific event. Initially, we worked out of the command center of the Southwest Bell Telephone Building. Downtown Oklahoma City was still in chaos. The streets were closed except to law enforcement and first responders. The structures around the Alpha P. Murrah Federal Building and the Daily Register were still smoldering. Cars in the parking lot were crushed from the force of the explosion. Rescue workers and their dogs walked through the rubble searching for survivors. Later, rescue dogs were substituted for cadaver dogs, and many first responders were desperate to find the remains of co-workers, family, friends, loved ones, law enforcement. Many federal agencies had offices in the Murrah Building. And behind the building was a Daily Register where many victims were catastrophically impacted. On the other side of the Murrah Building was a federal courthouse where the federal judges worked. Large shards of glass were embedded into office chairs, furniture, and the walls. How could this have happened in America's heartland? Merrick and I walked downtown, around and through the Murrah Building. As we walked by the daycare center, attached to the Murrah Building, an empty silence overcame us. Neither of us said anything to each other about our shock and grief, not until about 20 years later. We then went upstairs to one of the floors in the building. We saw a desk, a chair. There was a jacket on a chair, a can of Coke, paper still on the desk. But less than 5 feet away, where we were standing, there was nothing but open space. Without exchanging words, we knew we had to find the perpetrators of this unimaginable terrorist act. I knew Merrick, who would be leading the investigation, would ensure that justice would be done, would be carried out objectively and fairly. Emotions were not part of his decision-making process. Merrick is unwavering in doing what is right and has always demonstrated outstanding judgment. I worked with him weeks and months after the bombing and in Denver, where the trial was conducted. I saw countless hours he devoted to make sure that there were no corners cut and that justice was done. Under his leadership, he required the investigation to be coordinated through the Western District of Oklahoma with involvement from at least 8 different jurisdictions around the United States. It required tremendous coordination effort, which he led. And as his nature, Judge Garland was committed to making sure the investigation was conducted in the right way. Why? Because we owed the victims, the people of Oklahoma, and the people of the United States a thorough and fair investigation that comported with the rule of law. Merrick would accept nothing less. He relentlessly followed the law throughout this complex investigation. He was meticulous in requiring subpoenas were issued. There were complete records of how evidence was obtained. He made sure the applications for wiretaps, search warrants, and other investigative tools were reviewed and approved by each federal district where the evidence was sought, as well as by the FBI and the Department of Justice. Merrick worked closely with federal, state, local officials, agents, first responders. He made sure all voices were heard, and there were many voices. Merrick's a collaborator and consensus builder. He's always willing to tackle the difficult issues head on. While many in law enforcement had their own opinions of how the investigation should have been conducted, Merrick welcomed and listened to diverse opinions. His sense of collegiality and fairness and objectivity earned the respect of even those who may not have agreed with his decisions. His commitment to victim rights was strong and enduring. Judge Garland dedicated most of his professional life to public service, which includes his 2 decades on the bench. He's brilliant, thoughtful, kind, empathetic, compassionate, and down to earth. He's a serious person and does not shy away from making the hard decisions. He's a man of integrity, honesty, and fairness. I can attest to all of this because I know him. I was there with him in Oklahoma City, and I have worked with him in good times and in bad. He's committed his life to our country. He's extraordinarily well qualified to be our Attorney General. Thank you for allowing me this privilege to share my thoughts regarding the qualifications of Judge Garland, and I welcome any questions.
Thanks, Ms. Posella. Now we'll ask a few questions, and I'll start. Let me start with Ms. Tucker, if she would be kind enough to answer a basic question that I am asking, not just as a senator, but as a father and grandfather. I'm trying to visualize the relationship between Judge Garland and your children, particularly since I have found in my experience that many of my kids and grandkids are very skeptical of my wisdom until they reach a certain stage in life. How have your children taken to Judge Garland in a personal way?
Well, my son has had the last 4 years before the pandemic to get to know Judge Garland since he came to the school every week to tutor him. So he had a familiarity with Judge Garland. And my daughter always saw him getting tutored by Judge Garland, and she was kind of a little jealous. So she also wanted to get tutored with him, but they just seem to love Judge Garland. And like I said, he always asks how they're doing to get to know them on a personal level. So it's just easy for them.
Do they ever talk about the fact that he has another life beyond being a good tutor as a judge, maybe considered for the Supreme Court, now being considered for Attorney General? Are your kids aware of that?
Yes, they are. And we had several conversations in regards to that. And we also watched when Judge Garland was nominated by President Biden on TV, and they were just so excited. They were jumping up and down. It was like, that's my tutor. That's Judge Garland. So they know he's famous. I don't think they know the severity of it because they're still 11, but they know he's somebody.
Thank you, Ms. Tucker, for joining us today. Wade Henderson, I have a basic question for you. When we looked at the Reconstruction period, Jim Crow, there's been some great books written. I always recommend Carol Anderson's White Rage and One Man, No Vote. But it seems to me that the first vulnerability of the recently freed African Americans was the right to vote. And that was one of the first things that was attacked during Jim Crow. It still continues to this day. Voter suppression really focuses primarily on people of color, after all is said and done. Any comments in your life experience with this issue?
Senator Durbin, thank you for your question. It couldn't be more pertinent to the issues of the day. When the Justice Department was, the division was formed in 1870, as I mentioned before, one of its first tasks was to challenge the Ku Klux Klan for the violence that they perpetrated against newly freed, formerly enslaved people. That was 150 years ago. Congress enacted the Ku Klux Klan Act of 1871 to address that violence. Ironically, today, the same issues that affected newly freed African Americans at that time affect us and other communities of color today, literally 150 years after the enactment of the Ku Klux Klan statute. Recently, Congressman Benny Thompson, chair of the Homeland Security Committee, and the NAACP filed a federal lawsuit charging a conspiracy between former President Trump, Attorney Rudolph Giuliani, the Proud Boys, and the Oath Keepers to prevent Congress from certifying the election of this past year. And it was the Ku Klux Klan Act of 1871 that was the basis for this challenge. So as the great author William Faulkner once said, the past is never dead. It's not even past. The issues that motivated the challenge to African Americans 150 years ago remain a challenge to American democracy today. We are a nation at war with itself, and we need a Department of Justice that is committed to lowering the temperature and enforcing the laws as they exist today, with the understanding that every American citizen deserves the right to cast a vote when appropriate, and that right will be protected by the Department of Justice. Judge Garland is the perfect individual to carry out that responsibility, and in times like these, it is so important that an individual of his integrity and stature be chosen to represent the Department of Justice. Thank you.
Thanks, Mr. Henderson. Senator Grassley has told me that he has to go to a finance meeting.
No, if you got more questions, I can wait.
I'm going to defer my questioning so that you can take time for yours.
Then I'll go to the Finance Committee meeting. Judge Starr, you left the bench to go to the Department of Justice as Solicitor General. So what sort of advice would you have to Judge Garland that leaves the same court to go to be Attorney General?
He will be blessed with a very fine group of professionals throughout the department, overwhelmingly. But I must say, this independence of judgment and taking a careful look, presuming, as we say in administrative law, regularity, the presumption of regularity, but sometimes the department gets it profoundly wrong, and the Attorney General is where, in effect, the buck stops. So one very quick example. As I say in my written statement, during the Obama administration, the Justice Department took what I believe was an extraordinarily ill-conceived position with respect to religious liberty, trenching on values of the autonomy of religious institutions, specifically church schools. And the position taken by the Solicitor General, very able lawyers, was unanimously rejected by the Supreme Court. Not 5-4, not 6-3, 9-0. Justice Ruth Ginsburg joining, Justice Sotomayor joining, and a huge rebuke to the Justice Department. Where had the Justice Department gone wrong? It had gone wrong first at the EEOC. It took the position that religious liberty did not really count on the scales beyond simply associational liberty more generally, the Rotary Club or the NAACP. Important organizations, and they enjoy associational freedoms. But the Hosanna Tabor Evangelical School was a religious institution, and that, of course, triggered First Amendment values, very specifically those first 16 words. So there are times when, even with respect to the office that I was privileged to hold, the Solicitor General, that on issues of fundamental importance to our constitutional order, the Attorney General should be willing to focus on it and to step in and say, with all due respect, Solicitor General and your very able team, I think you've got this one wrong.
Okay, I have another question for you, but because time might run out, I have an important question for Professor Blackman. Historically, the Solicitor the Solicitor General's office has been seen as representing the permanent interest of the government, not political interest of any single presidential administration. Paul Clement, in that position, quote, said, "It has been the long-term position of the Justice Department to defend the constitutionality of statutes whenever reasonable arguments can be made," end of quote. So far, we have seen the Biden administration change its litigation position on a number of high-profile cases, and I would expect that might continue. So, two questions to you. I'm going to ask them both at the same time, Professor. If a case is being litigated, what's the standard for whether to change a position? And is a simple political disagreement enough? And how does the Supreme Court view an administration changing its litigation position?
Well, thank you, Senator Grassley. It's a pleasure to be here. In the past, the Supreme Court has been very critical of changes of position. During the Obama administration, Chief Justice Roberts in particular went after some of the lawyers from the government saying, why did you change your position? And the answer is always the same. Upon further reflection, we have a new position. And upon further reflection is really code for upon further election, right? There's a simple change in position. I would hope if General Garland is in the office and he decides to switch a position for the court, he gives some reason why. It can't just be we have a new president. If that's reason, then state it. But maybe there's some judgment about the law. But I suspect at some point the court will get annoyed that all these positions keep flipping on a fairly regular basis.
Okay, I'm going to go back to Judge Starr. I believe you're familiar with the Justice Department's recent practice of dismissing False Claims Act cases brought by whistleblowers. The Justice Department argues that it has unfettered discretion to dismiss any claim brought by a whistleblower. If legislation is needed in this area, I'm in the process of trying to clarify Congress's intent, which oftentimes DOJ or the Supreme Court gets wrong, and we have to correct it. And I've had a lot of help from Senator Leahy in regard to that. Based on your reading of the False Claims Act, what would be your advice as appropriate interpretation of the government's dismissal authority?
Yes, thank you, Senator Grassley. And I think that the government has taken, frankly, an unconstitutional position. It is seeking to arrogate complete authority, what it calls unfettered discretion, to dismiss a qui tam relator's suit, seeking redress against possible fraud against the government. And I think fundamental constitutional principles suggest that the interpretation of the law that has been given, including by my former court and Judge Garland's current court, the D.C. Circuit, is just profoundly wrong in our system of checks and balances. There is a key interest on the part of qui tam lawsuits, and that is of the qui tam relator, the whistleblower, and those merit much more protection than is involved in the opportunity, as one judge put it. The hearing before the dismissal of the lawsuit is ordered by a district judge is to give the qui tam relator and her counsel an opportunity to persuade the government not to do that. This, I think, it diminishes the judicial role, calls the Article 3 power into fundamental question, and arrogates authority that I don't believe, and I hope that you and Senator Leahy likewise believe, the Congress never intended in those magnificent amendments in the 1980s that you helped so instrumentally as really the architect of those amendments. Congress never intended to give the authority of that sort to the Justice Department Civil Division and ultimately the Attorney General.
Thanks, Senator Grassley, and I realize you have to go to another committee hearing. With the permission of the senator from Connecticut, the senator from Texas has a time issue. Would you be all right if I recognize him first? All right. Senator Cornyn?
I'll be happy to return the favor at some future date. Thank you, Mr. Chairman. Judge Starr, you've, during your distinguished career, you've had a lot of different hats that you've worn. One, of course, is as independent counsel, which was the predecessor to now the special counsel provisions that under which Robert Mueller and now Mr. Durham have been appointed. I understand why Judge Garland was reluctant to talk about the Durham investigation and what he would or would not commit to, but I would like to get the benefit of your insight and experience on what kind of advice would you give Judge Garland? What kind of advice would you give us in terms of allowing the special counsel to complete their job as assigned without the Congress interfering?
Well, the questions yesterday, Senator Cornyn pointed to the key issue. Will Attorney General Garland, once confirmed, support fully, completely, at a practical and moral level as well as a legal level, the ongoing special counsel investigation? Under the regulations promulgated by Attorney General Janet Reno in 1999, those are very strong and solid regulations in my judgment. There is a guarantee of practical independence subject to the overall supervision of the attorney.
On Judge Garland's nomination on Monday, March 1st, I thank all my colleagues, but especially Senator Grassley. We, as I said at the outset, have had a long-term friendship, which I'm careful to protect as much as possible. He is a good man and an honorable person, and I have enjoyed working with him over the years. And with that good news, the hearing stands adjourned.